cross-examination. The theories of cross-examination are very well penned down. All you have to do is read a couple of books. But the problem which really arises is this: how do you really apply it? Mr. Tulsi has in a very elucidated manner, with reference to Rajan Pillai's case, brought out the relevance. I shall really reflect upon it. But you see, historically, if you have bothered to read the papers at the Bailey's trials, where the origin of criminal law is to be found in the 17th and the 18th century in England, and at that time the Bailey trials decisions were just about put down in chronicles here and there, and that is from where the lawyers would really find out the strength of cross-examination. In the early parts of trials, as they were taking place at these Bailey's courts, there was no counsel representation. There was no cross-examination of the witness. The witness would come and depose, and the defense would bring their own witnesses, and the judge was supposed to then decide on the credibility of the witnesses on his own perceptions. Till it's interesting, a matter took place where this person was charged with felony, and at the end of the trial, when he was called upon to say what he wanted, he said, "I'm not that Mr. Smith regarding whom the trial is going on." Fortunately for him, the person who had made the accusation happened to be in the court, and he said, "Well, certainly he's not the Mr. Smith I had been talking about." And that is when they realized that the trials in Old Bailey's would last from 10 minutes to about half an hour. And then somebody sitting on these trials said that it's time enough that we give the defense some kind of a help, where somebody could be sitting to watch out what is going on. There were no formal lawyers at that stage. And when that right was given, we would have interjection when the witnesses would be speaking. And the person in the defense would say, "Oh, that's what you mean to say. You think you are the truthful person? Bullshit." And the judge would say, look, you have not to interfere like this. But so irresistible was the human wish to interject when somebody would say that the crime took place at 7 o'clock, and you said, 7 o'clock you saw the face of the witness. It's on the road leading to the jungle. There were no lights. It was all cloudy that day. I will prove it was. Yet you could see. You want the court to believe that. And then the judges said that, all right, we would give you the right to put all these questions to whatever you want to bring out the credibility of the witness at the end. And many regret that, because effectively it gave the opportunity to the lawyer to wrest away the trial from the control of the judge and take control of the trial. You have got that right. Now the question would be that how effectively you utilize it. Now, Mr. Tulsi, with respect to the Rajan Pillai's trial or inquest proceedings, whatever they were, I have no idea of it. And since I entered virtually towards the end, question of inquiry, right? He brought out that how they went about looking at where was he staying, what was his condition, what was he eating, what was he drinking. Now, what is Mr. Tulsi actually speaking about? When we look to the provisions of the Evidence Act, they're very simple, but for very unexplainable reasons, I find that people tend to trivialize what is simple. And I'm reminded, once Michelangelo's friend, Michelangelo, as we all know, is a great sculptor. A friend of his went to invite him over for dinner, and Michelangelo said that he was very busy with this sculpture of a lady which he was making. And he said, if you would come back after 2 weeks, let me see whether I am free. So we went after 2 weeks and Michelangelo said, look, I'm still working on it. He said, okay, he said it's near complete. I don't know what Michelangelo is talking about. It was nearly complete. It was just about the same what I saw 2 weeks back. It continues to be the same. But well, he says, I'll come back after a week. So we went after a week and Michelangelo still said, well, I'm still working on it. So we went after another week. He said, I'm still working on it. So 3 months went by. So his patience got lost. He said, look, Michelangelo, if you don't want to come to my house for dinner, why don't you have the courage to say so? What are your pretense of looking busy you are making? He said, look, I'm not making a pretense. He said, what have you done in the last 3 months for this sculpture? He said, when you came to me 3 months back, I saw the ridge of the nose was not a little correct. So I chiseled it like this. But when I chiseled the ridge of the nose, then I realized that it's a side pose, the reflection of the ridge which should come on the other side. So I needed to chisel it on this side, then I cut the lip a little finer here, I did this, I did that, and so on and so forth. His friend said, trifles. And Michelangelo said, trifles make perfection, and perfection is no trifles. So it is these trifling things which we overlook. It is which gives the perfection, I would say, the lethal cutting edge to a cross-examination. Now what do you really do apart from these other provisions when we look at section 7, 8 and 9? And I would say the cross-examination must center around 8 or 11 concepts which emerge out of these provisions, and keeping in mind one fact. That a fact is defined under the Evidence Act is a thing, state of thing, relationship of things which can be perceived by the senses. We all know we have 5 senses, and everything else relates to an opinion. And one more, the mental condition of what a person is conscious of. So what do? You prove facts, and then from those facts proved, inferences are drawn. So at the cross-examination, you have to keep in mind that when this witness is talking of something, what is he trying to prove? Well, we say, oh, he's trying to prove at a murder trial that I'm a murderer. Sorry, no, he may be a witness to a motive. So he's not trying to prove that you're a murderer. He's only trying to prove that you had a motive, and then you must understand that he is now going to talk in terms of something which has got to do with my mental condition. Now if you have a look to, when we look to section 7, what do we find? 3 words: occasion, cause or effect. So facts which would be the occasion, cause or effect. And then we would say a state of things under which 1, 2 or 3 happened. A state of things under which occasion, cause or effect took place. This is where you have to look at what is my witness speaking about. Is he talking of an occasion which I had? Is he talking about a cause? If he's talking of a cause, then obviously you would relate that he's talking to a motive also under section 8. You've got to be extremely careful. Is he talking of an effect? Oh, I ran away from there. Well, you'll be referring to it as a conduct. Opportunity and occurrence are 2 more words which we find a mention under section 7. And then when we look at the motive and the preparation, you find that the motive part relates back to the cause part of it. What caused the man to do what he did? And then of course we would have the preparation as an independent concept. Then if you see under section 9, time and place. Now what did Mr. Tulsi tell us? When you're looking to Rajan Pillai, what was he doing immediately before you are talking in terms of Rajan Pillai in relation to his relationship with the things. What were the things? What was his relationship with the things? The food which he ate, the liquor which he drank, in relation to his physical health. So what were you talking about? You went down to the court to cross-examine, conscious of the fact that here I have a charge and I am having a person whose state and relationship of things was X, Y, and Z. How do I use it now? What to say? To ensnare. You have to ensnare your witness. And if you put a trap, it's so obvious, you think your witness is going to walk into it. After all, he's also a person of reasonable intelligence. Now where does that take us to? It takes us to that as a cross-examiner, you have the benefit of a charge being laid. And not the charge as we frame in India, it's most unfortunate that I hereby charge you that within my jurisdiction on such and such date, you murdered. That's not a charge. A correct charge, according to me, subject to correction of the law teacher here, should be that having an ill will towards so and so on account of the fact that you believe that the deceased was having an evil eye on your wife, you entered upon his house with a knife with the intention of using the knife to cause death, and in furtherance thereof, you stabbed him thrice on the stomach and caused death at a place within my jurisdiction. The witness, because that's what's laid in the charge sheet. Now what happens in the trials? Where do trials go wrong? You don't read the charge sheet again and again. You are having a person going to say that this man believed. You may not have to prove that he actually had an evil eye on the wife, but it's enough for the prosecution to prove that the accused believed that the deceased was having an evil eye. Half the time I find, well, the prosecution is going to prove, and he says, oh, he's not able to prove that he had an evil eye. But that's not what was intended to be proved. What was intended to be proved was a fact of the mental condition of the accused, that he so believed. And it's enough for a witness to say that this man came to me twice to ask me that has he seen my wife speak to this man when she goes to the market? Has he seen this man speak to his wife when she goes to the municipal tap? Now suppose he were to say that. Now he's not an irrelevant person. He has thrown light on a cause which could have induced the motive. So it is this incisiveness, if you don't do, to what is your witness then speaking about? Now how do you do if you don't know this? Then cross-examination. Well, don't the people in the colony gather there to collect the water? Is it not known that the water comes for these 2 hours? And is it not that the water doesn't come with that regular frequency, and people do ask each other, has the water come? Is he the immediate proximate neighbor? Would it not be reasonable for him to ask the immediate neighbor who's coming back with an empty bucket that has the water come, or has the water after not even come at all? Or on a question that is it a matter of fact that after 7 o'clock, when the shops close, the street vendors come and sell the same ways at 1/2 the price? Sometimes they come at 7 and sometimes they come at 7:30. Now you see, it is this which is absolutely needed for the purposes of what are you going to cross-examine your witnesses. Now those of you who've been in the High Court in appeal, I refuse to believe that every accused is right-handed. I never come across an accused with a left hand, and I used to actually tell some of the lawyers here that every case when I am looking at the post-mortem, it is reflecting, and the line of questions would be from the trajectory of the wound, from the positioning of what the witnesses are talking about, as if every accused has used the knife in his right hand. And it's not possible. When you look to data, you find that 0.1% of the population in the world is left-handed. So applying those logical principles, 0.1% of the accused should also be left-handed. I've never seen anyone look at the post-mortem reports to look at the distance from the foot where the injury is caused, vis-a-vis the height of the accused. We've never seen the cross-examination in respect of whether the quarrel origin was on a thada, which had 2 steps, whether the stab wound was inflicted on the thada, on the first step or on the second step. Was the accused on the thada? Was he standing on the road when he attacked? We don't see that at all. When you ask somebody, oh, what's the relevance of, say, the MLC? Would say, well, the MLC relevance is the medical condition of the person. Now, is it not showing a relationship of 2 persons brought by? Is it not in conjunction with the first DD entry at the police station? Not reflective of the relationship of time? Would it not relate to when the evidence comes that the distance between the place where the crime took place and the hospital was 2 kilometers and the mode of transport was such and such? This brought by could be relating back to the bystander who was standing there at that time. So how do we understand? When we look at the law of evidence, when it says relationship of time, relationship of person, relationship of things. That's so extremely, extremely important. Now we look at the post-mortem report. A dead body speaks a lot. Its weight, its height. In relation to the accused, I don't know if those of you who have done, I'm sure Mr. Tulsi would have seen so many appeals. You don't find that kind of, very few, I'm not saying nil, but we don't find any. So let's take virtually, if not more, at least 1/4 of the crime murder cases would relate to the wife being the victim. Now we haven't gone to slums. Everybody is so vulnerable over there. Anything could happen. And then the argument is, oh, it's happened in the jhogi, he must have done it. Nobody outside heard it. Now I find this argument strange. Now whether I stab my wife in the jhogi or somebody else comes and stabs, she would give a shriek. Now nobody not hearing it, the answer is very obvious. Wife bashing is so common, or somebody or the other is shrieking in a jhogi. So a shriek in a jhogi would not attract anyone. But then when you look at the case law, what do you find? Now here comes another element of cross-examination, that you ought to also be careful of what are your substantive laws. And at the end of the day, when we talk in terms of evidence and preponderance of probability at a civil and a criminal, it's a myth actually. You know, while writing the same judgment, you're sitting on the civil side, so you say the evidence on preponderance probabilizes this. When you're sitting on the criminal side, you know that this expression is the most inappropriate expression for a criminal judgment. But then, what are you doing? The judge puts the question to himself, as a reasonable person, on a reasonable line of logic, am I reasonably coming to this conclusion which somebody would say it's a reasonable conclusion? So you use reasonableness 4 times. But that's actually what happens. So that's a sharing which a lawyer must understand, that the judge would appreciate it on 4 principles of reasoning of reasonableness, as a reasonable person who applies the reasonable logic to come to the reasonable conclusion which a reasonable person would accept. And then after having said so, it would be just about the language on which you would try to pen down. Then let's take the importance of a substantive law. You look at the case law, and what do you find from the judicial decisions coming from the Supreme Court? They say, upon proof of no motive, but proof of presence of the husband in the house, he must speak. So you apply section 105 and the presumption 114. Second, they say very weak motive. Presence in the house not proved, but the time of the crime is such that the presence in the house should be reasonably expected to be there. 11 in the night, 1 in the night, 4 o'clock in the morning. They say you are entitled to a reasonable inference 114 till he speaks of the special knowledge which he has. You apply section 506 of the Evidence Act. Situation 3 of the Supreme Court says, very, very strong motive. Presence in the house not proved. Likelihood of being in the house not being ruled out. Conviction. Motive. Presence in the house not proved. Time being such, not expected to be in the house. Likelihood of being or not being there, acquittal. Now once you know that these are the 4 categories in which substantive law, right or wrong, I'm not at the logic of it. Well, it's there, it stands. Now here is a matter where, let's say, the type of crime could be 9 in the night. The doctors opined it's in all probable 9 in the night. Now would a lawyer not know that here my cross-examination should try and bring out admissions where I could take the time away from 9 and not towards 10 or 11. I should try and take it towards 8 or 7, because here what I am looking at, that the crime was not reported by somebody saying there are cries coming from here. The crime got reported when somebody said that I am seeing some blood oozing out of this house. So the first information report is not proximate in point of, the first information to the police is not suggestive that the crime took place then. It has taken place a little earlier. Now it is here that we find, no, in what category you are being put, we don't find any cross-examination. The entire charge sheet is based on circumstantial evidence. And like a huge amount of cross-examination sometimes you find on the Rukka or on the registration of the FIR. Now if you're talking of anti-timing, what are you talking of? Planting of a witness? That he wasn't there, he got planted out. But if the crime is that somebody says कि garbage bin में से बदबू आ रही थी तो मैंने जरा उठा के देखा कुत्ते वहाँ पे घूम रहे थे, so I also inquisitively walked there and shuffled through and I saw a dead body over there. Now even for this, what I'm just trying to say is that, is it some kind of a meaningless exercise going on? Are you conscious of your destinations? Now in common day life, who reaches his destination? He who starts his journey from the correct spot and takes the first step in the right direction. If you don't start your journey from the correct spot, or you don't take your first step in the right direction, you will never reach your destinations. So the direction is given by the law, and the spot are the facts. And it is here that you really need to see sequentially, it has to be sequentially, that what do I relate myself to? Now suppose in the first example of the crime which I gave, that the doctor says it's 9, and you have a witness speaking in terms that I saw him around there at 6 o'clock. Now it becomes Mr. Tulsi want to leave, it seems. Yes, yes, why not? You are, so you don't have to be formal on these occasions at all. Please carry on. Now you see, the lawyer gets a very good opportunity now, that where does he target himself now? He would be stupid to bring the cross-examination on the doctor to take the time towards 7, because somebody's spoken of his last scene at 6 o'clock. So if he's going to take the time of crime at 7, he's creating lethal evidence for himself. I've never seen a lawyer, when the doctor has testified that the time of death is 9, to make a request to the court that I'm going to cross-examine this doctor, because I would like the last scene witness to be cross-examined. Strategy is coming up. Because if your last scene witness were to stick to his version that you saw him at 6, then the lawyer can sit back and now choose that my last scene is sticking, and this advantage of law, which I wanted to take, that the time is such that the husband was not expected to be or something, I'm stuck up. This guy said he saw me leave from the factory and he saw me, at the Panwala, which is about 50 meters away from my house. So what do I do now? Would I be more beneficial to try and shift the time to somewhere? I'm very consistent with my defense of having gone somewhere else or not. I don't know what it is. But the point ultimately is that it's the prosecution's job is to create the web around you. And let's be truthful about it for all what we do, but the truth we know that our investigations are far from satisfactory. Except for when an eyewitness surfaces, the only thing which the Indian police would do, कि ये last किसके साथ था, and catch that guy and holler him up. Sadly speaking, we do not bother as lawyers on cross-examination. And let's see, for those of you who've done trials, I'm speaking of criminal murder trials, because in other matters when the witnesses are there, in a case of injury or any other, they're relatively better and simpler because the victim would be speaking over there, you don't land up. And there it's just the cross-examination of the witness to bring out a motive or so on and so forth. But where is the incisiveness that my job is not to totally smash through the net as long as I'm happy to create an escape route? I don't have to escape through a net by puncturing through the net. A fisherman puts in a net. He's conscious that he has to pull it out in a manner that the fish can't go out. Because if you put in a net like this and you pull it out like this, all the fish will go out. You've got to pull it out like this. There's a very good book which I would recommend to you, Stephen Hawkins, written on the rule of law. He's written, it's called the rule of law, but not the rule of law which we understand. He's talked to laws of nature. And he says what happened, it's his human quest is for knowledge and to unravel the mysteries of the world. And he said what happened? When earthquakes would take place and floodings would take place, people could explain those phenomena and they put it to God. Till somebody became more inquisitive. He said, sorry, you can't, let's understand. And he started understanding why volcanoes were there, and he started understanding why earthquakes could take place on tectonic plates shifting. So you say, look at the Semitic religions of then, Greek, Babylonia, Hindu religion. You would worship the Lord of the fire, the Lord of the rain. But nobody believes, I haven't seen a temple for Lord Indra now. Because we all understand that why do floods come? Why is there excessive rain? So you don't have to pray to the god of the rain now. So you don't find temples for Lord Indra now. You don't pray to fire now because we all understand why volcanoes come. So he writes a little more, and that's very relevant for lawyers. He said, why is the Pythagoras theorem not called the law? And why did Newton's laws, what he discovered, were called laws? He said the Pythagoras theorem was a phenomenon. The hypotenuse of a right angle triangle, the square of that is equal to the sum total of the square of the two others. He said it's a phenomenon. But when Newton saw apple falling, when the laws of motion, the law of inertia, he said, why were they laws? Because they could be predicted on a formula. So somebody then discovered the formula. Now see how close it comes to a courtroom issue when lawyers come down. As the physicist went for the quest for truth, what was the quest for truth? That is there a God? Can I explain these phenomena as happening on something and then I disbelieve on God? That's what a criminal trial is all about. And that's all about a normal trial. It's a quest for justice. It's a quest for truth. And whatever can be empirically brought out, and then what is not explainable, we tend to say the benefit of the doubt. But then he says that whatever remained as the doubt, the physicist, that's what Stephen Hawking says, what remained as the doubt was put on the account of God. But then he said that quantum physicists moved in. You know, Newton's theory of motion would explain every phenomenon, but when you reach the speed of light, it fails. But then nobody was satisfied with that. The quantum physicist walked in, and we had quantum physics. Now what's the relevance of this when you talk in terms of cross-examination? The lawyer must know that here is my case on fringe areas, akin to the quantum physicist who understands that the law which we are talking in terms of is at the fringe areas. And can I now put a derivative to the phenomenon to explain it with relation to how do you put in a court of law on a derivation? The example which I gave with the last scene at 6, the time of crime being at so and so. He has two routes to charter. He's also akin to a situation where two conflicting theories are coming in. And then he brings in, Stephen Hawking brings in Max Planck's theories of the laws of the probability of uncertainty. And those of you who studied physics would understand it when he says that if you have to measure the speed of the object and you have to determine with precision its location, if you are more accurate on speed, you will be less accurate on position. And if you are more accurate on position, you will be less accurate on speed. And he takes out the Max Planck's theory of probable error in the location of the two. See how relevant all these theories get related to. As the origin of the universe was all philosophical theories. These are philosophical theories in law which we talk in terms. And today when you look to the richness with which the world is trying to recreate those same theories, because when we look at decisions, people find, why is it that a Sessions has said in conviction, the High Court has said it's an acquittal, the Supreme Court goes back and says the Sessions was right, why is it the Sessions and the High Court are agreeing, and the Supreme Court says we're not agreeing with it? People ask questions, and they answer it by saying that what is happening? Lesser and lesser empirical, fact-based application to criminal law is missing. And more of it is left to the subjective satisfactions. It's caught the attention of one of the professors in the United States of America who did a very good experiment. He picked up children in the age group of 3 to 5 and 5 to 7 and 7 to 10. And he put them all in a room, as you all are. He gave them a buzzer each. And he said, if you ring the buzzer in the first 1 minute, you'll get 1 chocolate. So 1 chocolate is yours. You ring the buzzer right away, you'll get it. You ring the buzzer after 5 seconds, you'll get it. But if you don't ring the buzzer in the first minute, and then you don't ring it till the next 2 minutes, then you get 2 chocolates. So you ring it up within the first minute, including now, you get 1. If you cross your 1 minute, then you have to cross another 2, you'll have to be 3. Between 1 to 3, you'll get 2. And beyond 3, if you don't ring the buzzer in the next 7 minutes, you'll get a box of chocolates which would contain 10 chocolates. So what would you answer? What was he testing? They agreed? Well, yeah. So he was testing their patience. So when he found out that not one in the first age group could last more than a minute. About 20% of the next age group couldn't last the first one, but 50% could last the next span, and very few could enter the third but couldn't cross it. In the highest age group, he found that all of them crossed the first stage, nobody rang it in 1. Then he found that about 15% couldn't last the next 2, and 80% couldn't last the remainder. So just about maybe 1 or 2% could. So he said, now, okay, I have something to do with patience and with lack of understanding. But he said, lack of understanding of what? They all understood that if they lasted for 10 minutes, they'll get a box of chocolates. So he said, it's got nothing to do with patience which I talked of. He said, it's too trivial. But he said, I have subjected them to a test, I must find out what has happened. And he said, yes, of course. It's very easy. Now when you understand what's happened, then it becomes very easy. He said, each one of them, when I told them what they were to get by way of reward, each one of them had a first order desire and a second order desire. He said the first order desire of each was to get the box. But there was a second order desire to get the chocolate immediately. So he said it was neither the greed, it was neither the patience. It is actually a conflict between the first order desire and the second order desire. Then he says, look at crime. When you say spur of the moment, sudden and great provocation, he's lost the mental balance. He says there is revenge in all. If you've done something wrong to me and I hit you back, it is revenge. Undoubtedly, he says, it would be revenge. But he says that the first order desire of every person would be not to take the law in your own hand and wait for the results to be delivered as per law. But then you have a second order desire that, look, he's wrong, I've been wronged. Let me bring it in straight away and, get over that feeling of insult which I have. So he talks of it that can we create a theory of a static mens rea vis-a-vis a dynamic concept of mens rea? Could we use this experiment that today he said anyone above the age of 18 stands at par? Could we bring in a concept of a dynamic mens rea? That a person at 19 needs to be looked at a little differently on a sudden and a grave provocation? Or he looks to be looked at a little differently when we talk of upon a sudden quarrel? Vis-a-vis a person who's 30 years of age, vis-a-vis a person who's 50 years of age. Stephen Fleming picks up this very illustrative practical experiment done, where he says that, look, how did somebody discover air? It was a simple, the Ionians prior to the Greeks, they actually laid the foundation for most of the scientific theories and laws. So they would keep on experimenting. But before Archimedes got the principle of buoyancy, the Ionians knew that you put an object in water, it resists. So they understood the phenomenon, but they couldn't relate it to the volume of water displaced equal to or equal not to the weight of the object over there, but they would understand. So somebody had a ladle. A ladle is what? It's like a hollow thing in between with the holes. So you would say you put the ladle inside and it will go down and there would be water. But then somebody just put his thumb on the top of the hole of the ladle and he says the water was not going inside. So you say, yeah, there's something inside this which is obstructing the water to get inside. And it was this inquisitiveness which led the society to think more and more. So when Stephen Fleming, Mr. Stephen Hawkins, he looked at this test conducted by these analysts, and he says, can I relate it to what scientists do? He said, yes, I can. He said, what does a scientist do? He empirically sees and perceives something with his senses. And then he tries to rationalize it and try to explain it on a rational. If he can explain it on one rational, it starts getting some acceptability, but if he can explain it on two rationals, it gets a greater acceptability. And then he says that it is this experience which he sees, which enriches his quest. And this is exactly what we do when we talk of evidence. Do we try to ever enrich ourselves as lawyers on cross-examination with the little richness of these everyday mundane things which we see in life? Today you see I've been often in the courts been telling lawyers that cell phone as a technology has removed one big area where criminal law has its foundation, that oh, this person was there at the spot, his presence is being proved because this person has removed this person to the hospital. Now see what happens. Let's take a father gets an information in his house that his son has been stabbed on the street, which is 100 meters away from the house. He reaches that place in less than 1 minute. His first thing would be from bystander, who's done it, who's done it, who's done it, and we don't know. In that confused state of mind, he would have birth of two. His first order desire is to take his son to the hospital immediately. But somewhere there is a second order desire, who's done it to my son? He's not got an answer from people over there. The mind will start rolling. Oh yes, who could it be? Yeah, yesterday he had quarrel with such and such person. Oh, that person could be. Then his wife would come down and you ask the wife, he said, "हाँ, बारी पहले भी उन दोनों का झगड़ा हुआ था." Then he said, "All right." By the time the cop has come, he's weaved a story. Has anyone asked him that you possess a mobile phone? To try and test that, did he receive a call around the same time? Is there a possibility that he wasn't there, but he reached there faster than the police? Now, we had this origin when mobile phones were not there. And we still tend to appraise these facts. As a judge, you are entitled to, because the lawyer has not brought it out. But this is the relevance which a scientist looks at. And that's the relevance which I think a lawyer in terms of cross-examination would. I would just sum up by saying that a good cross-examination would mean a complete digestion of the charge laid, not as framed as I said in the charge sheet, keeping an eye that these are the witnesses who are going to speak of motive, these are the witnesses who may be speaking about a last scene, this would be the witness who would be speaking of so-and-so, here have I a case of an eyewitness account, I have 2 witnesses on eyewitness. And then in relation to the injuries, I've never seen cross-examinations as to how is the wound traversed inside the body. Is it acute angle at 45 degrees, going upwards? Is it going downwards? Nobody is asking questions of in what manner the blow was struck. Simple enrichment of language. Oh, the friends were there sitting on the nala, and they were gambling on tossing on a coin, and they started fighting, and then they just say, oh, they fought in the evening, there would be a motive, and in the night, if this guy was sleeping over there, he must have killed him. And nobody would ask, what do you mean by quarreling? Were they squabbling? Were they quibbling? A quarrel is a very aggravated form. Preceding a quarrel would be a squabble. Preceding a squabble would be a quibble. We don't enrich ourselves to ask these questions. Oh, husband and wife fighting, he says, oh, bade jhagar rahe the. By those standards, I think I'm in perpetual war with my wife. But if all those quibblings which we have is fighting, and well, then we've been now married for 25 years, and multiplied by 365, we must have at least, by those standards, fought on 1,000 days. It's a hell of a lot. But then if it's just that you say that, look, I want a green colored shirt, you say, oh, green color looks extremely stupid. I said, no, it looks very cool sometimes. He said, you were stupid. I said, yeah, of course I was stupid, I married you. He said, you think so? I said, yes, of course. Then you say, oh, they were quarreling, they were calling each other stupid. Now, that's not the way to look at things. So it's about what? It's richness of language. It's a richness of content. It's a richness of your experience. And above all, it's the richness of your purpose. So you have to enrich yourself. And why do I say that? Because the world lives in 4 directions. So these are 4 directions from which you can center on the same point. All others would be relative in terms of time, in terms of other dimensions. And I would say that of course, we have all these theories of open-ended questions and closed-ended questions. They remain as but theories. Yes, it's good to have a theory because it helps you to formalize yourself. But what's the point if you have the theory and you don't know the substratum, the material where you have to do that? I don't know how many of you are here at the trial court level. You don't have to call us to enrich you with whatever you have to speak on. I think the lawyers at the legal aid in the High Court, they would be in a far, far better position. See, we had one matter, I think Mahajan, you argued that where this fellow was accused of murdering his wife, who was a paraplegic. One side was paralyzed. And I asked the prosecutor one question. I said, if this fellow in his 313 would have taken this defense what would have been the fate of this case? And he said, sir, I concede it would have been an acquittal. Now what had happened was, he got married to this woman who was paralyzed on one side, and she was a TB patient. And she was at a very late stage of tuberculosis, with the post-mortem said that the lungs were totally gone. There was one injury on the scalp here, and there were injuries on the back of the right hand. There were some injuries on the chest. There was none on the neck. I said, suppose this fellow said that when I entered the room, I saw her gasping for breath. And I had seen some gibberish, I had some gibberish impression of artificial resurrection. And I thought that if I were to pump her chest a little, she would be facilitated in her breathing. And in the process, her body was jerking up, and the head hit the pyre of the bed. And since she was gasping for breath, when I was doing that, her arm was flustering all over. So one side was paralyzed, it didn't, and this explains all the injuries on the back of the bum. So I said, just this statement made under 313 would have earned the man an acquittal. Well, he hasn't said it, so it's fine, he is suffering for what he is to do. But had he done that, what would have been? So it was very obvious that nobody looked at the alternative. Nobody looked at the alternative. See, I see no lawyer cross-examining ballistic experts, and there were 2 acquittals by me in the High Court with respect to loose-fitted bullets. You see, when you are using the Desi firearms, these are loose-footed .303 or whatever may be the dimension of the bullet. Nobody bothers in cross-examination. It's your right to call for the expert, because his report can be tendered in evidence under 293 CRPC. But with respect to the prints of the test-fired bullets, on what basis is he saying that he's basing his opinion? No cross-examination done that it was a loosely fitted bullet. It's rubbing against the barrel of the pistol would not yield those kinds of striation marks which otherwise on a proper firearm would be there. I don't find anyone. In fact, I must have dealt with about 35 to 40 matters of ballistic expert, and it was very sad to see that no attempt was made by the lawyer to summon the witness or even subject him to cross-examination. So when forensic evidence comes, you have to enrich yourself on the forensic part of it, to look at it, and all I would say by ending up would be that it's to determine whether an object has come out in the perfect shape, it's a 360 degrees look. So this provision which says relationship of time, place, person, events which are the cause or of effect, immediate or otherwise, these words must ring into the minds of the counsel. And immediately he must spring on the thing that this is relating to whatever part. Now somebody said, demeanor of a witness. Now how many of us would know that what makes admissible in evidence the demeanor of a witness? So can somebody tell me here? It's very obvious. Why do we call direct or percipient evidence? It's the evidence which the witness gives or what he perceives from his senses. When a witness is in a state of demeanor, he reduces his status to that of an object. and he is capable of a direct and percipient viewing by the judge. So you have reduced that witness to the state of an object, and then tell the judge, now he's an object before you, you will use your direct and percipient evidence. Now why do we say that why direct and percipient evidence is better than circumstantial evidence? Not that the man may also be telling a lie. What gives it a quality of better evidence? When it is subjected to the credibility of the witness, it's very obvious that in a direct evidence, when we talk of, it can only suffer from one taint. The witness may be a liar, just one taint. But once we believe the witness, then there is nothing left for the judge to infer. He says, I believe this witness. So the taint is one. What indirect? Why do we say it is weaker evidence? It has two taints. The person who's giving testimony of a fact may be telling a lie. The second taint may be that the inference which you draw may not be the correct inference. So qualitatively, one suffers one taint, qualitatively the other suffers the second taint. Now what's it relevant for cross-examination? Relevant is that if you talk an eyewitness talking, then you know that till you don't get over the taint of credibility, you are left nowhere. But in the second one, you must be smart enough on a cross-examination that I don't have to demolish this witness to prove a particular fact from which an inference is drawn, as long as I can introduce something on which the presumption which the court will draw gets dented. Because ultimately, what presumption would you draw? You say that from a given set of facts, unless something is brought on record on which the reasonable inference is based, is not dented, it's permissible to take the reasonable inference. And if a fact comes in which breaks the reasonable inference, now let's take a case of the circumstantial evidence, where the witness says that I was standing at the bus stop, I saw a man wearing a red sweater running past, and after 2 minutes I saw this accused with a knife in his hand run past me. And there's some other witness who's established that 500 meters down, this accused was found, the victim was found fatally stabbed with the knife. So 5 minutes prior, you've seen the witness has seen the deceased run by. 4 minutes past, he's seen the accused run by with a knife in the hand. It's very lethal evidence on which a reasonable inference would be drawn. But suppose one question, he says that, is it true that I was asking, whereas, have you seen a hen go by? And on proof of the fact that he was a butcher over there, selling hen in the market, the inference which is to be drawn by way of a presumption has now been broken by a chain of facts. So that's the way we have to understand on cross-examination. I just close by saying over cross-examination. We have seen certain cases of convictions coming on over cross-examination, and I would do no better with one a live example which took place. There was this lady, I'm forgetting her name, she was a very great actress in England, and somebody morphined her photograph and put her in very suggestive clothes and published an advertisement. She was livid about it. She gave a notice to the publishers and they apologized about it, and they also put in a written apology in the paper, and yet she sued for damages. So up comes the lawyer for cross-examination. He said, "Madam, you have a very good reputation in the theatrical world," and she said, "Yes, of course, that's true." And when you enter the stage at the start of the scene one of your show, there's a round and a very loud applause of clapping, and she said, "Yes." And he says, after this was published, it continues to be so. You are acclaimed so well. She said, yes. You don't find the applause being a little less than what it was? She said, no, I find it even more. People have become more appreciative of me. He said, when you gave the legal notice, we tendered an apology. She said, yes. He said, we not only tendered the apology, but the newspaper report was also published about it. She said, yes. He said, even after it was published, the applause continues to be the same. Yes. Madam, we also express regrets to you about it. She said, yes. Then came the fatal question. Then why have you sued? She said, because I want the world to know that I wasn't the person. Because the apology wasn't with that we have morphined it. So he said, I want the world to know that I am not that. So one question, fatal, and that's what we really have to understand, that it is only when you are breaking either the credibility or the inference which a court would draw on what the statement is being made by the person. If you reach that stage, I think it should be fine. But again, the question would be that how would you really do it? Till you don't break the statements of your witnesses that this part is relating to an inference which is personal to the witness. This is only the factual content which the witness is talking about. This part the witness is talking of a time. This part the witness is talking in terms of the place. Now see, more often than not, there are three witnesses to a particular incident. So one says, I didn't see the accused. Somebody is saying, I've given the accused. The lawyer in cross-examination is forgetting that the person who says that I saw the accused has also said I gave him a chase. The other one has got more engaged in giving some kind of a rescue to the injured person. And you just left, right and center cross-examination is going on. Now three people will react differently when they see a crime. Somebody may say that, look, let me chase the guy who's done it. Somebody said, let me give rescue to the person. And somebody just sits there, he says, oh, this guy is giving a rescue, this guy is doing, let me just hang around and see it. But then, what's the point to cross-examine them indiscriminately? And then you land up, and in the process, you land up not cross-examining when he's corroborated the presence of the other. And at the end, you want to somewhat say that A wasn't there. And up comes the defense to say that, well, when we talked of I was taking tea with A, we saw this. He's very happy by saying, कि तुमने तो उसकी शक्ल देखी नहीं, ये नहीं था, वो नहीं था, and he's forgetting about that. So how that intricacy web is also creating is important to see. It's difficult to put all these things in a theory, but these are some of the very broad ways of looking at it. Of course, the topic is such that you could, enrich it with a lot of experiences. And really speaking, that was the idea when I said you don't have to have any kinds of speeches, because it's the experience which keeps on enriching you. So with more and more examples of as judges, sometimes we see, as lawyers what we see, and it should be an ongoing sharing process. See, what's going to happen is that ultimately the law of evidence would remain in the realm of criminal law. It's dying as far as civil laws are concerned, because today what we find is that in civil laws everything is getting well documented. It's all getting well documented, and there's a belief, and I am an earnest believer, that the rules of pleadings of the Civil Procedure Code need to be changed. We said them in 1908 when 95% of the cases had 100% oral evidence. And today 95% of the cases have documentary evidence. So pleadings of suits could become pleadings akin to writ petitions, pleadings of law, fact and evidence, and it would purely remain. And as Mr. Tulsi rightly said, mental gymnastics is as interesting as physical gymnastics. Those of you who are at the trial court level need to be conscious of that it's the poor man feels that he gets no justice. And when he looks at the rich man's getting the acquittals in jails, and he gets his conviction, and if he does feel that the system is totally loaded against him, we need to rise to the occasion. Thank you very much. Do you have any questions on?
Your Lordship has been showing his surprise over why the questions are not asked of the post-mortem report as such. The basic, I would like to say on my legal fraternity, the kind of post-mortem report which are given at trial level are so illegible, and the kind of writing which and the kind of terms which has been used over there are just beyond the realm of a criminal lawyer.
Well, I could only say that it was never beyond my realm. I was not a criminal lawyer. What is the harm if, surely in your colony there would be some doctor who's somewhat known to you? I think those of you who've been appearing in my court, the summoning of that doctor from the dispensary was a very often exercise. We would also not understand, and because there was no cross-examination, so you would ask him that what exactly is this? Now you see, that's the point. Ask what kind of interest are you going to take in the matter? And if you enrich yourself, you will find slowly and steadily that you will be able to read all of them yourself. So you say that it's illegible, alright, you say it's illegible. But if the doctor comes, have you ever bothered to ask him, "Bhai, ye tune likha kya hai?" Even in those cases, I find nobody's asked the doctor, "That what have you written? We can't read what you have." And then you're not even bothered to ask him what does he mean by it. Now let's take normal matters. How many of you would be knowing, it says subdural hemorrhage? Well, it's the least, it's the first. Dura mater, pia mater, subdura mater. How many of you are aware that there are 3 layers of membranes enwombing the brain below the scalp? And just because the doctor says, "Yes, Mr. Mahajan, there are 3, I suppose." The outermost one is the dura mater, then the subdura mater, then the pia mater. Oh, subdural hemorrhage. Oh, the lawyer judge says, "Oh, 302, 302. Whereas it is the least used force. It's only when there is subdural hemorrhage, it's greater use of force. Very rarely you come across where even the pia mater is affected, and if the skull is scalped away, the whole brain is out. That's the kind of enrichment when we talk in terms, when you get down in. How many of you would tell the judge that, "Sir, this is not subdural hemorrhage"? He's not talking of, he's just talking of the dura mater. It's the first membrane at the top. Nobody will cross-examine the doctor that is it because of extravasation of the vessels which has resulted in some swelling at a particular place. How many of you have judges? I don't think so, madam, you ever found those issues of cross-examination coming. Then what could be the impact of the force used on the head? The physical condition of the person concerned, brittle bones, non-brittle bones. Let's take a man is at 70. The use of a lesser force at the age of 70 would be sufficient because the bones have become brittle. That's the point which we are trying to say. There is no point to say that, look, I am handicapped here, I am handicapped there. You're not handicapped at all. Stage 1, when the doctor, in fact, why should you reach for the stage for the doctor? How do you know you have to cross-examine him till you've not been able to read his post-mortem report? You should have consult a doctor around. Alright, no problem. If you don't want to consult a doctor, you don't know what prevents you from moving an application before the court that I've got an illegible document, I'm not able to read it. Please get a supplementary challan file with the direction to the IO to get a legible written. Do you do that?
Never done.
We never done that. Now let's take it may become too late. The doctor may have dead and gone, and somebody else is going to prove out his report in relation to his handwriting. How many times we see that the poor victim may have said कि भी मैं तो उस वक्त दादे की दुकान में काम कर रहा था, and वो register maintain करता है. Nobody after the charge is framed will move the court. So please maintain that register. And by the time the defense evidence comes after 3 years, the lawyer is bound to come and say, "Dada, मैं तो कच्चा सा register बना था, फेंक दिया मैंने, है ही नहीं मेरे पास." You see, we don't particularly do that. Now let's take it's on a last seen evidence at 4 o'clock. Now we had a session, you had a client counseling. So first of all, the problem is, the guy said, मैंने नहीं किया. बोले यार अच्छा भी तूने नहीं किया, पर देखिए गवाह बोल रहा है कि तू यहाँ पे था, और तू देख ले अगर वो कायम रहेगा ना तो फिर मुझे मत कहना. ये नहीं साहब वो था तो सही, पर वहाँ क्या हुआ, मैं उसके बाद वहाँ चला गया था. कोई तेरे पास सबूत है कि उसके बाद तूने वहाँ जाके चाय पी थी? से हाँ जी बिल्कुल, उससे जाके पूछ लो. We don't do those kinds of exercises, and we land up with huge problems. Now we're forgetting that these decisions, all this was framed when there was, there were no megapolises. Today in the city of Delhi, crime takes place for nothing. The man has parted company with you, he's walking down, he just rubs his shoulder with somebody else, and he says, साले देख के नहीं चल सकता, बोलेगा 2-4 माँ बहन की, बोलेगा तेरे बाप की सड़क है, बोले तेरे बाप की नहीं, क्या मेरे बाप की सड़क पे है, और तूने ऐसा कहीं को बोला, and up comes a stab and he's gone. And poor fellow, 10 minutes back there is a last scene. He won't ask the cop that, look, you have made the scene of the crime here, but my last scene is here. There's a road in between. And ask the witness, जब तूने देखा फिर क्या देखा, फिर क्या मैं उस तरफ जाते हुए देखा तूने मुझे? बोले हाँ जी इस तरफ जाते हुए देखा था. Nobody will even ask him those questions. That okay, you saw us last scene together. For how long? You just saw us stand and talk? Or last scene, then after the last scene what happened? Now suppose he were to say after the last scene, this guy walked on this side and I saw this guy on this side. Then just on a little proof, a little more, you got it. But we don't find it happening. There's no client counseling which is going on. Yes, please?
We don't find our judges believing us. Problem is this.
Well,
we do these kind of exercises. I've got a case. In that case, the honorable judge didn't even give the bail to me. The last seen evidence was of 4 days back.
Okay.
And on that, a murder case was being...
Well, we'll put it like this. The blame game continues. Many feel that the time has come. We had the Canadian delegation. You were there, madam, when the Canadian delegation was there in the High Court. We had judges from Canada. And it's a warning signal for all of you. 50% of the litigants in Canada have started arguing their cases themselves. Because they find that the legal cost is not coming commensurate with the services which were to come from the lawyers. 50% was a large number. And why did it come? Because an average clerk or a junior level manager in Britain, we have somebody here from Britain? You've been there?
Been there, but not from there.
Alright. About 25,000 to 30,000 pounds per annum. A plumber, an electrician and a carpenter would be earning about 80,000 pounds per annum. And then somebody says, what does this plumber do? He brings a wrench. Very simple, he opens it up. There's a little washer inside. So he said, yeah, now I also understood. There's a big stop clock. Isko band karo. And they said, go and buy a wrench. They started doing their electrical work themselves. They started doing their carpentry job. They said, if we can do this, why can't we argue for ourselves? Why can't you can access the law on the net? How many of us know that the ILI has digitalized 80% of its library, which is on the net free of cost? You don't. You go about searching all over place that I don't know this and I don't know that. But I'll specifically answer your charge. The citizen tells the judge that why is it that 90% acquittals are taking place? and you're making a grievance of the 10% convictions. Now let's understand that technically speaking, no case, a loss of life cannot come back unanswered. It's sad, it's a sad reflection for a society that it comes back unanswered, and that's, our statistical data are not too very fair. But still, the question would be that how sequentially you put your argument. So many times we find just block statements coming. I would say that in appeal, I would welcome lawyers to say that, sir, the case against me is based on circumstantial evidence, a motive, a last scene, conduct of running away, and recoveries of the blood-stained clothes and the weapon of offense. So the most lethal of this is last scene. The other three I'll deal with it in the end. And if I'm able to demolish, and if he demolishes the last scene, you just term it up by saying, motive, presumptive evidence, treated weak evidence, conduct their judgments both ways, and as much as accused run away, even people out of fear run away. And here are the two judges of the court that Indian police does blunting. The fulcrum is gone. If the fulcrum is gone, what remains? Nothing remains. And a little bit of physics. What is the law of lever telling us? The distance between the fulcrum and the length of the lever will determine by what ease you can lift the weight. See, when we look at all this, we don't use our now these small things. If somebody says, what's the use of studying physics for a lawyer? What's the use of chemistry for a lawyer? All these things, you can correlate it empirically very well. Yes, aberrations would be there, but we're talking in terms of by and large.
So one question, sir. In the case of sir site plan, whenever the site plan is prepared by the IO,
Yes, we just move on. Yes.
so whenever site planning is prepared by the IO in criminal cases, sir, it sir talks about sir crowdy road, but it is never shown, sir, the presence of sir vehicles or the person, sir.
How can he do that?
But sir, in accident,
Because he was not there when he prepared it. Those vehicles have gone.
But sir, the point is, it is easier to convince the court, sir, about the speed of the vehicle in question, which is involved in the accident, about the, sir, the width of the road. It is never mentioned, sir.
So then that's a matter of cross-examination. At least the width. Look here, what vehicles he saw when he went there. He wasn't there, so that's irrelevant at the time of the accident.
Right, sir.
But there is certainly cross-examination that look, this is an area within your jurisdiction. इस पे कितना traffic चलता है, कितना होता है, are you aware of it? Yes, why not? But then it's a matter of cross-examination. You're right. I think we're getting some messages that the room has to be vacated. There's somebody else around here? Yes. So the time is up. Right. That's a big problem. Time constraints are a big issue everywhere. You know, in a lecture hall here, we thought that we would have all the time. So another thing that you have to keep in mind, the time constraint which the judge would have for your cross-examination. Thank you. Yes, that's what I said. We must do away with that.
Still, we
And
are
yes.
grateful to his lordship.
Yes, there are no thanks. There are no thanks in sharing knowledge, because I think he who takes his knowledge with him has done great disservice to society. It's supposed to live as your legacy. Thank you.